This bill isn't about the right to farm. This bill is about limiting protest and transparency. And the Greens firmly believe that we should have at least truth in legislating, and therefore we're moving to amend the title of the bill to have it called the Limiting Protest, the Right to Farm bracket, Limiting Protest and Transparency bracket bill. This is about Parliament being honest about the impact of this legislation. This legislation comes from a pretty ugly political place. It's not about the right to farm. It's about the right for agribusinesses to farm with cruelty and to limit the protest and transparency that I believe and the Greens believe is essential if we are going to stop that kind of systemic cruelty in parts of particularly corporatised agribusiness.
Minister, sorry.
Thank you, Mr Deputy President. The new proposed title by the Greens Right to Farm Limiting Protest and Transparency Bill 2019 is not reflective of the content of the bill and would mislead the public record. We will not be supporting this amendment.
The Animal Justice Party is particularly concerned with the limitation of transparency. This is simply reproduced Ag Gag legislation based on similar legislation that's been pushed through in the US. The name of the bill, as it stands, fails to recognise that this bill is entirely about limiting transparency within animal agriculture. The bill is yet another superficial attempt to appease lobbyists from the powerful animal agribusiness industry and frighten whistleblowers into silence. But if animal agribusiness genuinely believes there is no ethical issue with modern factory farming practices like cramming tens of thousands of chickens into
Order. Look, again, I've made the point before, this is not an opportunity for a second reading speech.
My point, though, Mr Chair, is why the bill needs to accurately reflect what the bill is. And so I'm reminding the House what this bill actually seeks to do and why the words transparency needs to be included in the name of the bill.
Again, you are straying too far.
This isn't about right to farming. We had an inquiry that showed very clearly that this was not going to address the issues in the own public consultation that's been running since 2015 about right to farm. This doesn't respond to the issues that were raised then. We know that the nuisance shield provisions are actually more likely to impact farming, so it's dishonest. The aggravated offences which are being strengthened here, they were introduced by the Baird government to go after coal and gas protesters. It was about protest. It was about limiting protest. That's the name of the amendment.
There have been incidents around this state and indeed Australia where restaurants and butcheries have been stormed by vegan terrorists during business hours. In Melbourne, a steak restaurant was stormed by over 30 vegan terrorists from the group calling itself Direct Action Everywhere Melbourne. They invaded the restaurant, they verbally abused the customers, staff and owners there. They are vandalising and threatening businesses, scaring away customers and costing people their livelihoods, and even worse, getting away with it. Let us not pretend that these vegan terrorists are not across every loophole and gap in legislation that they can exploit. They now have representation, indeed, in this parliament. They have refined a business model around the harassment and intimidation.
Take a point of order. The member cannot refer to members in the chamber as terrorists, and that's what he just did. And I'd ask him to withdraw the comment. It's directed at members of the Animal Justice Party, which is who he indicated.
Directed at the party, it's right.
It's directed at members, and he cannot, and it's unparliamentary to refer to members on this House as terrorists.
I just ask that everyone keep the debate at a good level, and we'll all proceed accordingly. The member may proceed.
Thank you, Mr Chair. This is an organised criminal behaviour. They are a crime gang masquerading as a cultural movement. Human welfare always comes first, over the concerns of elitist animal rights.
Sorry, Chair, I fail to see how the argument and the amendment put forward for this particular amendment has anything to do with the nuisance section of the Act.
To the point of order.
The Honourable Robert Borsak to the point of order.
Mr Chair, it's fundamentally an explanation of what this redefinition is all about. Human welfare always comes first over the concerns of elitist animal rights protesters who care more about the welfare of chooks than humans. I urge all members to support these sensible and much-needed amendments which will improve, protect and tighten the bill.
The government opposes the Animal Justice Party amendments which seek to remove all provisions of the Right to Farm Act. This amendment does not deliver the government's objectives in providing lawful primary producers a bar against nuisance litigation.
I rise to support the amendment by the Animal Justice Party and the amendment by the Greens, and oppose the amendments by the Shooters, Fishers and Farmers Party. I have read the Minister's second reading speech, and it is a very odd explanation of why Parliament needs to act in this way. Why is this nuisance shield required? To quote the Honourable Adam Marshall, quote, complaints about normal and legal farming practices against primary producers occur all over this state and threaten daily operations. Those complaints are commonly around the incidental and accepted farming practices such as noise, dust or odour, among others. These are basic realities of farming and the basic realities of living near a primary production operation, unquote. I asked the Parliamentary Library to conduct research into how many such nuisance cases were adjudicated in the last 10 years in New South Wales. They came up with a blank.
It seems odd that the shooters are proposing to give a specific nuisance shield to, say, butchers, which is clearly picked up by B2. So a butcher in the middle of Westfields has a protection from the nuisance, any nuisance laws, but the greengrocer next door not covered. It's a very strange approach. I don't quite know what the rationale for that is. I don't know why they so dislike people who sell vegetables.
I'll start with the amendment put forward by the Greens. The Animal Justice Party strongly supports this amendment. It's very concerning to us that under the draft bill, a commercial agriculture operation could completely change their operation from something completely inoffensive to neighbours to something highly intrusive, but still be immune from a nuisance lawsuit just because they have been doing some form of agriculture activity on that land for 12 months. The change could be as drastic from going from a winery to a piggery or a chickpea farm to a slaughterhouse. According to this government, as long as there has been any kind of agriculture on the property, the next door neighbours should just have to put up with it without any legal recourse in nuisance. I move now to the amendment by the Shooters, Fishers and Farmers Party, and I rise to oppose this amendment. Like the government, the shooters, fishers and farmers have provided no evidence or statistics about why such a nuisance shield is required. This amendment puts the rights of the animal agriculture industry above the rights of private individuals to enjoy their own property.
That they have chosen. So no matter what your perspective in this debate, everyone should come together, one, to accept that there should be a statutory review, and two, that it should come sooner rather than later.
The Minister.
Government does not see a 2-year statutory review as necessary or effective.
Mr David Shoebridge.
The Greens support this amendment seeking to have a review. It's interesting the government noting a 2-year time frame and saying it's inadequate. The same government that in just the last week has instituted a review of the Independent Planning Commission after only 18 months of operation. It seems to me that the time frame adopted by the government is more determined by the nature of the inquiry rather than the principles as to what should be a reasonable time in which to consider a review, and this is obviously one of those cases. 12 months in jail for perhaps damaging offence, or 12 months in jail for if you find, say, a hen in extraordinary distress, actually saving that hen from systemic cruelty. And to put someone in jail for 12 months for those actions, the Greens believe is disproportionate. When if you cast your mind back in history and you think about the precious parts of this state that have been saved by those very actions, forestry blockades to save rainforest, the remnant rainforest that's now left on that coastal strip in particular of New South Wales. If we had these laws in place, we would have lost that rainforest because we couldn't have done community couldn't have done those blockades. The idea that we would be passing a law to put someone in jail for up to 12 months because they incite somebody to go onto enclosed lands is deeply, deeply troubling. And I say that as somebody who has incited and encouraged people to go into state forests and actually blockade and stop forestry activity.
Whether you agree with the objectives of protesters or not, whether it's the suffragettes seeking votes for women or people protesting against the Vietnam War or people seeking to preserve the rainforests in more recent times. Overreach of the kind represented by this legislation could well fall foul in the High Court.
And these amendments were universally slammed in the Upper House inquiry from groups across the spectrum, from animal and environmental groups to unions to legal groups. The lone supporters of this section of the bill at the inquiry were the intensive animal agriculture industry, which is not surprising given they are the group that are being propped up and shielded by this bill. There has been a growing collective awareness of the mistreatment of animals, particularly in intensive animal agriculture systems, where animals are held in overcrowded cages or sheds, living miserable lives with severely compromised welfare with the sole aim of increasing profit margins for industry. This section of the bill has been touted as a way to stop animal activists from protesting or gathering evidence of cruelty. But the question is, why are they protesting? So how does the government respond to this? With legislation that seeks to reduce transparency to consumers and the general public and stop protesters from campaigning against cruel and often legalised practices to animals, such as the continued use of cages in the egg industry. Our laws are so weak in New South Wales that we see animals surgically mutated without pain relief, hens imprisoned in battery cages without the space to even turn around, and chickens grown so obese that their fragile legs break from underneath them. These are all legal practices, and the public deserves to know this. Sometimes obtaining undercover footage is the only way, and that's why we support Schedule 2 being removed. But what happens when the government refuses to take steps to end oppression of a group or species? You create an uprising. So don't be surprised when 14,000 members of the community go in to rescue those hens that you've chosen not to protect with legislation, or trespass to capture footage of their suffering so their deaths can mean something. Whether Schedule 2 passes or not, people's concerns will not go away. And if you continue to introduce legislation that fails to protect the most vulnerable members of society and actually entrenches their suffering, our community will not stand for it. Our community will continue to take action to protect the most vulnerable citizens, including animals. People are protesting because the government is failing to protect animals through the legal system.
How long did that take?
The Honourable Robert Borzak.
I was like, geez, was I going to take a point of order? I think that's a vote of support. The Honourable Robert Borzak. On a point of order.
Mr Chair, the honourable member is well outside the standing orders in requiring and advocating for people to commit crimes outside of this place.
The member may proceed.
Thank you, Chair. People are gathering evidence of cruelty because there's no transparency in the animal agribusiness industry, and people are becoming angry because the primary enforcement agency does not have enough money as a privately funded charity to prosecute the majority of cases of animal cruelty.
Order. Can I just indicate that line is beyond.
To briefly restate our concerns, the Animal Justice Party is opposed to the government's amendments to the Enclosed Lands Act, and we support the amendment to remove Schedule 2 because the offences and penalties, not to mention the minister's rhetoric around the bill, have inappropriately targeted animal activists, despite there being absolutely no evidence that advocates have caused any increase in trespass in this state. This is not an evidence-based law. It is a pathetic attempt to appease powerful farming industry lobby groups and address an illusionary problem that does not exist. Animal advocates are not creating any problems in this state that require them to be targeted with legislation, especially not through legislation that has been so poorly drafted and the consequences of which have been so poorly thought out.
The Honourable Robert Borzak.
You're obviously now back again into a secondary dispute. I mean, how long do we have to put up with this, honestly? Another 7 minutes?
As per the clock.
Mr Chair, I do note that it is ironic that this bill is trying to silence people who want to protect animals, and then in this House I'm being silenced speaking out.
I'm not seeking to silence. Order! So, again, I'm not being critical at all, and I'm not trying to shut you down, but there is a requirement that you speak within the standing orders.
Okay. The amendments fail to address the number one cause of rural trespass in New South Wales, illegal hunting, in a targeted and evidence-based way. People in this place are probably sick of me bringing up illegal hunters, but I have to make up for the fact that the minister...
Well, she's flouting your ruling, surely. What has illegal hunting got to do with this amendment?
Chair,
The bill.
as mentioned by the Honourable Adam Searle, this is about removing the entire Schedule 2.
Schedule 2 doesn't deal with illegal hunting.
It does.
Hunting
It
itself.
does.
It does not.
It does.
You can't read.
It does.
Point of order.
No, look. I'm going to invite the member to proceed.
Okay.
The member is proceeding apace, and I'm sure she will continue to.
The bill will have a chilling effect on participation in and organisation of political protest activities due to the draconian penalties and introduce offences regarding incitement. The right to protest is particularly important to reflect on today, as this morning we saw thousands of protesters gathered outside Parliament. We cannot allow the people of New South Wales to be restricted in any aspect in their right to participate in peaceful political protest on agricultural lands or otherwise. We need to be able to continue to hold the government to account, and I strongly urge everyone in this place to support this amendment.
The Minister.
The government opposes the amendments from the Greens, the Animal Justice Party and the opposition, which seek to remove all changes proposed to the Enclosed Lands Protection Act. Farmers really do suffer enough at the hands of Mother Nature. They're desperate to have their businesses protected from people who wish to illegally disrupt them.
The Honourable Mark Latham.
Mr Chairman, One Nation believes quite strongly that if people go out of their way to damage the property of others, the state should lock them up. But can I just make a reflection on the changing nature of protest? Because I listened closely to the Leader of the Opposition, who spoke quite accurately about the role of the suffragettes and the Vietnam moratorium, and mention was made of rainforest protest. But that was then. This is now, where politics has fundamentally changed and the nature of protest has changed. Each of those protests mentioned from decades ago, sure, had something to say in the public arena, but ultimately had an intellectual content that relied on the Parliament trying to get a different result. And if you examine the speeches made in Parliament about the Vietnam War, or you go back to the suffragettes, there was an attempt to use the public arena, both inside and outside the Parliament, to influence the opinion of others. But unfortunately, protest today has changed. The left has lost its powers of persuasion, its attempt to raise argument, put the intellectual case. And you only had to listen to the Honourable Emma Hurst to hear what they're up to today. Because she basically said she's been elected to this Parliament. She's been elected to this Parliament.
David Shibridge on a point of order.
There were a series of points of order raised directed at the Ms Emma Hurst, alleging that what she was putting strayed beyond consideration and went to some philosophical second reading speech. That is exactly what this member is doing, and consistent with your earlier rulings, I'd ask you to bring it to order.
Do you want to say anything on the point of order?
Well, no, I don't, because I'm responding to things that have been said in the debate. I'm not reading out a prepared text that someone wrote for me in the office. I'm responding to what's been said into debate. All the debating points about the nature of protest, about what they're doing now, are fair game in a parliamentary forum where we actually debate things responding rather than just scripting.
The debate having strayed, I think the Honourable Mark Latham is entitled to have his two penn'orth worth. But I do invite members just to understand that there is a set of standing orders and people are going too wide. The Honourable Mark Latham.
Thank you, Mr Chairman. I think the schedule should stand and the bill should not be amended as suggested by those opposite, for the reason that the nature of protest has changed. We're in a very polarised political environment, not necessarily the best thing, but it's a reality. You go outside the Parliament and you go onto private property and you harass and trespass and intimidate and destroy and wreck and try and hurt other people in the name of your cause. Now, that I regard as fundamentally anti-democratic. And my home is my kingdom. And I think your average Australian thinks fair play, I do what I do on my property and I try and work hard and advance myself. And those who want to come on and wreck and destroy and hurt, of course you'll get a response. And I think what we do here in locking up these trespassers and these wreckers is actually avoid a lot of conflict and ultimately violence on these sites. Because going outside the democratic forum when you've been elected here is wrong. Your average Australian doesn't think that's a fair go. They don't think it's right. and I won't be supporting it for a nanosecond.
The Honourable Mark Pearson.
Thank you, Mr Deputy President. The Stephen Bradshaw report that investigated thoroughly all of these concerns about rural properties and trespass came to the conclusion that the most fear, the most harm, the most destruction, the most disruption was caused by hunters who trespassed, broke fences, shot across properties, shot at animals during the night, right next and adjacent to the property. This was the finding.
The Honourable Robert Borza.
Obviously not speaking to this amendment. What he's doing is pontificating about what he believes hunters may be doing or not doing. It's not relevant to the discussion that we're having here now in relation to the debate on this amendment.
Look, I have to say...
Chair, does it talk about hunting, breaking through fences or other things?
Precisely the point.
Well, look, I've got to say this. I invite you to consider, as you make a further amendment, a further contribution as to precisely what the amendment is.
So the reason I have stated what I have stated is that the Minister has couched the whole argument for the purpose of this schedule in relation to animal activists coming onto properties, where in fact the former police commissioner who was engaged by the government to research this very issue came to the conclusion that hunting was the main concern that farmers need to have about their privacy on their property. That's my point, and therefore the schedule is not focusing on what the harm is.
Our party has been advocating for this sort of law for the best part of a decade. I chaired the inquiry into surveillance on farms, and I saw in camera evidence, and I listened to in-camera evidence of impassioned speeches from, not even speeches, speaking from the heart of farmers who have been victimised not once, not twice, not 3 times, but dozens of times with trespass after hour. And it was this fellow here sitting there that did it. He sat there and did it. And they were absolutely in tears. I could not, in my heart of hearts, thought that I would see that in this place. Forget about illegal hunting, forget about all sorts of other things that relate to, or that I'm responding to you. What I saw in that inquiry hurt me to the core. Marauding protesters who think they have an absolute right to tip sugar into people's diesel tanks, to chain themselves to bulldozers, put up tripods in the road of businesses that are trying to legitimately and legally make a living. This stuff has to stop, because people like that are going to come backwards and forwards until they destroy absolutely everything. Absolutely everything. Sneaking into people's farms. Forget about factory farming. It's not just factory farming, it's all sorts of farming. It doesn't matter what it is, they will go out and try to destroy it. And the Shooters, Fishers and Farmers Party will always oppose that, because we're biased for the bush, and that's the way it's going to be.
If we want to have a talk about the history of protest and how protest has changed, I mean, I don't think that it was popular in the parliament when some of those initial environment protests were happening. There were definitely supporters in the parliament, and then there was activism out there in the community. In fact, that's what we've got right now. We've got people representing those interests in the parliament. They were elected democratically, reflecting a legitimate public view that it's out there, and that view is being reflected in actions on the ground. And I said in my second reading speech, and I say it again here because it's particularly relevant to this schedule, we do farmers in this state a disservice to pretend like that legitimate community movement around animal welfare is somehow illegitimate. Because it is not, it is real, and all you do is exacerbate the divisions that lead to these sorts of debates that don't actually help the problem.
Contribution by the Honourable Mark Latham, suggesting that the reason why his party was supporting this bill was because somehow protest has changed. Looking back at some mythical past where protest didn't challenge and seriously challenge authority is ignorant of the history of protests. And I'll just raise two historical incidents of protests, which we probably are all familiar with. The one is Emily Davison. Emily Davison is most famous for an extremely brave moment where she threw herself in front of a horse at the Epsom races for the right to vote for women. Eventually, brave women like Emily Davison, breaking laws, making noise, making a nuisance of themselves to authority, got the vote for women. And those people who support Schedule 2 would have put her in jail for 3 years or more if they could. And to suggest that somehow protest in Australia has always been some kind of polite engagement with authority, where you politely ask authority for permission to do things and you don't break laws. Ignorant again of history. You can go to the Great Depression, where there was the Battle of Union Street just in Erskineville, where squatters, unionists and squatters, took up residence in those properties in Erskineville because they had no money, they had no job, they had no income, the government wasn't helping them, and they illegally occupied residences in Erskineville. And they did it for month on month on month because that was the only way they could find somewhere to have their family safe and sheltered. And what was the response of the government? Well, it'd be the kind of response we've seen from those supporters of Schedule 2. They trucked in 40 police, they shot them.
Just, you know what's to do.
There's a proud history of protest, and criminalising protest, when you consider what it's achieved in history, is offensive to the Greens. I'm glad to see it's offensive to the opposition. I'm glad to see it's offensive to the AJP, and that's why we move these amendments.
A person who is protesting about the rights or protection of animals should not have any less rights than someone protesting about forestry. Both are valuable pursuits and should be equally protected under civil liberties.
The government does not support this amendment.
The Animal Justice Party is 100% opposed to any form of violence. In fact, non-violence is one of our core values. And anyone who gives rise to a serious risk to the safety of a person should suffer serious consequences. These people are fooling around irresponsibly with deadly weapons on someone else's land. These are the people that rural families should rightly be terrified of. It's fair to say illegal hunters are the real vigilantes this government should have focused on from the beginning. However, their near silence on this issue, especially after the New South Wales Police indicated it was the bigger area of concern, is astounding and shows that this bill is simply a political play. I'm concerned that the bill as drafted targets animal protection workers through tiered penalties, creating serious problems and inconsistencies. Under the bill as drafted, a person could commit an aggravated trespass offence, such as carrying a firearm into a school or a knife onto someone's home, and be subject to a maximum penalty of 50 units, while at the same time a group of 3 members of the community that walk into a slaughterhouse to capture footage of animal cruelty without any weapons, creating an offence to business operations, could face 200 penalties or up to 3 years imprisonment.
And to listen to the Honourable Justin Field, he said he wanted to protect peaceful protest. Well, these are not peaceful protests. These are people who are going onto private property for destructive purposes, to hurt income, enterprise, livelihood.
Animal welfare organisations may find themselves at risk of inciting offence simply for posting about animal cruelty at a certain facility or encouraging people to take action to stop animal cruelty.
Most of these so-called activists are not otherwise employed and would not be able to organise, much less afford, to travel to continuously protest. Just think of the cost involved. We know from past failed prosecutions that third-party funders commission subcontractors to engage in these illegal invasions and other activities. The use of professionally paid protesters is a large part of what actually goes on. Large organisations with ideological agendas should not be allowed to commission illegal terrorist activities whilst bankrolling them, organising them and encouraging the breaking of the law.
I had a phone call from Hawkesbury Valley Meats Abattoir from a worker there and his colleague saying to me after the expose on 4 corners of the horrific abuse of animals, cattle in Indonesian abattoirs, listen mate, if you think things are bad in Indonesia, come and have a look at what's going on with animals here at Hawkesbury Valley Meats, 45 kilometres from Sydney. All authorities had been called over 2 years. Nothing had happened to improve the welfare and protection of those animals, but also the workers who were there. One would say he and his colleague, his friend, incited cameras to be placed in the abattoir, which caused the abattoir to be shut down by the Food Authority and the police after all the authorities had been knocking on the door of the abattoir and nothing had happened for 5 years. Is that innocent person concerned about his fellow workers' well-being and the welfare of the animals somebody who is committing a crime? And that is what this legislation would intend to do.
Thank you, Mr Chair. Consistent with the opposition's position to delete Schedule 2 in its entirety, we do support the AJP amendment to remove the proposed 4C.
It seems to be just as ridiculous as the other aspects. Incite is the one that bothers me particularly. For example, if I found myself very upset about a particular thing, and that could potentially, my story could potentially incite someone else to go and take an action in relation to that. And I think that then to blame the person who shared the information would be an incredibly dangerous precedent to set.
Some years ago, in my previous role, slaughterhouse workers broke into their own workplace and installed hidden cameras. They were not activists, they were not animal lovers. They were just two men who decided that the brutality that occurred every day at this New South Wales abattoir should be shown to the world. The footage they captured exposed the shocking case of animal cruelty, the most shocking case of animal cruelty that we've seen in this country. But before anyone asks why they didn't just alert the authorities, the answer is that they did. The RSPCA told them that they wouldn't take anonymous calls, and the DPI attended, but of course the beatings stopped once an inspector was present. I have heard from many slaughterhouse workers crying to me down the phone, desperate for another way, and telling me that once the inspector left, it was back to beating pigs' heads in with metal pipes, raping sows, kicking calves, or jumping on turkeys. This would happen over and over and over to each animal unfortunate enough to end up at that slaughterhouse. If you find that hard to listen to, imagine how hard it is for that whistleblower to watch and to have no avenue to speak out and resolve the issue. Eventually, they usually lose their job or leave their job, and they do so in a state of distress, knowing that the abuse of the animals will continue to occur in their absence.
The amendment put forward by the Animal Justice Party is commendable, and the opposition will be supporting that amendment.
The government opposes the Animal Justice Party amendments, which seek to insert an exemption for informants. This amendment seeks to create an exemption for informants or those providing information about alleged offences or requesting an investigation by a person or body. The government does not support this amendment as it is unnecessary.
The Minister.
Thank you, Mr Deputy President. The government opposes the Greens amendments. This amendment seeks to create a defence for someone committing an offence for the purposes of investigating animal cruelty or environmental offences. The government does not support this amendment as it feels it's unnecessary. Those with animal welfare or environmental concerns should report their concerns to the authorities.
If it wasn't for activists, the ACCC could not have done its vital work exposing consumer labelling issues in respect to Pepe's ducks and lover duck. Footage filmed undercover showed ducks living inside dry sheds with no outside access or water for swimming. All the while, Pepe's Ducks was advertising their ducks as open range and lover ducks as range reared. Both of these claims were false, and the ACCC was able to commence proceedings under the Australian consumer law for misleading and deceptive conduct. Both companies ultimately admitted contraventions of the consumer law and were fined hundreds of thousands of dollars. This important exercise in consumer education and holding wrongdoing companies to account would not have happened without undercover footage.
Placing illegal cameras is no substitute for the legitimate right to protest or strike if it relates to the conditions or indeed work processes or animal cruelty. There is a right way to deal with cruelty if that's what you believe is happening in the workplace. Breaking the law is no breaking the law is no answer.
The government will be accepting the amendment from the shooters, fishers and farmers.
Question is that this bill be now read a third time.
Mr President.
The Honourable Mick Veitch.
Thank you, Mr President. At the conclusion of my second reading contribution, I said that the opposition would reserve their position on the third read depending on what occurred or transpired during the committee stage. Despite the extensive committee stage and even with the amendments that were made, we are still not satisfied that this piece of legislation, as crafted, meets the objective the government said it's meant to meet. It is still a poorly crafted piece of legislation, and we will be opposing this bill on the third read.
The Greens will be opposing the bill on the third read. We do acknowledge that there was some minor advances in the committee, particularly in terms of the protection for people engaged in unions and others engaged in industrial action. But the amendments that have been secured have gone nowhere near addressing our very large principal concerns with the bill, so we'll be opposing it on the third read.
Mr President, the Animal Justice Party clearly will oppose this bill on the third read. It is actually a piece of legislation which strikes down some of the very principles of protecting the most vulnerable in our community. Not only animals, but workers and people who choose to take the risk to report what is completely offensive and criminal behaviour, and it's actually punishing the whistleblower rather than upholding the principles of our society. So therefore we oppose this bill on the third read.
There being 19 ayes and 18 noes, the question is resolved in the affirmative. Unlock the doors. Clerk.
Right to Farm Bill, third reading.